And here's a big breaking story of the hour. Sanjay Roy, who has been convicted of raping and murdering a junior doctor at the RG Medical College and Hospital in Kolkata, has been sentenced to life imprisonment by Sealdah court. In fact, the court noted that it was not the rarest of the rare cases. Sanjay Roy, a former civic volunteer with the Kolkata police, was in court when the sentence was announced. The victim's family and CBI had asked for death sentence to the alleged rapist and murderer. However, now the court has given him a life sentence, life in prison, and a fine of 50,000 rupees, calling it not a rarest of rare case. I'm joined by my colleague Saurabh Gupta for more on this. Saurabh, I believe the parents of the victim will not be happy with this, with the verdict coming out. Neither will CBI be. Are you hearing that this is going to be further appealed to a higher court?
Well, it's a natural progression of the legal process that it will go to the High Court, and the parents are likely to push for the death penalty in the High Court. And the court, of course, the Federal Court, trial court here, felt that the case was not in the rarest of rare category. That is something that the judge said very clearly in the courtroom before announcing the sentence. And the sentence is, of course, there are several charges, so he's got life imprisonment on all three charges, along with fines, 50,000 rupee fines, and then, of course, if he can't pay the fine, then that sentence also goes up, which means that he will spend a lifetime in jail till his death. But this is not the death penalty that, there was a lot of demands from, not just from the legal sort of teams in the case of the prosecution and from the victim's family, but also from society at large, including the Chief Minister of West Bengal, including political parties, all have demanded, the death penalty. However, for the death penalty to be awarded in law, there are very strict provisions. Now, many believe that it fell into the rarest of rare category because of the heinous, brutal and horrific nature of the crime. But also there were legal voices which said that this is a case that largely rested on circumstantial evidence. Apart from the forensic, the electronic, the CCTV, all of that. So considering the evidence before the court, and the judge made it clear that I have to consider the evidence, and based on the evidence only before me. This was, he said earlier in the day. So obviously when the sentencing arguments were taking place, but the quantum of
बांग्ला में हम बोल रहे हैं आपके सबके लिए ज्यादा से ज्यादा ओके বাংলা আমি আপনাদেরকে জানাচ্ছি এই মুহূর্তে অ্যাডিশনাল ডিস্ট্রিক্ট এবং সেশন জাজ শিয়ালদা 1 নম্বর কোর্ট তিনি আরজি কর কাণ্ডের মূল অভিযুক্ত সঞ্জয় রায়ের ব্যাপারে তার সাজার মেয়াদ ঘোষণা করেছে। গত 18 জানুয়ারি 2025 সঞ্জয় রায়কে সেখানে দোষী সাব্যস্ত করেছিল বিএনএস অ্যাক্টের 64, 66 এবং 103 এক ধারায় 3টে দোষ সেকশনে আজকের যে সাজার মেয়াদ ঘোষণা করেছেন এই মুহূর্তে সাজার মেয়াদ বিএনএস এর 64 ধারায় অর্থাৎ রেপ ধর্ষণের জন্য তাকে যাবজ্জীবন কারাবাস এবং ফাইন, একই সঙ্গে 66 ধারায় যে ধর্ষণ এবং ধর্ষণের সময় তাকে যে আঘাত যাতে মৃত্যু হতে পারে সেই কারণে বিএনএস এর 66 ধারায় আমৃত্যু কারাবাস এবং 103 এর এক ধারায় অর্থাৎ খুন বা মার্ডারের জন্য তাকে যাবজ্জীবন কারাবাস এবং ফাইন করা হয়েছে। একইভাবে স্টেটকে নির্দেশ দিয়েছে ভিকটিমের পরিবারকে 10 লক্ষ এবং 7 লক্ষ মোট 17 লক্ষ টাকা ভিকটিমের পরিবারকে ক্ষতিপূরণ দেওয়ার জন্য। हम हिंदी में बोल रहे हैं जो आपका एडिशनल डिस्ट्रिक्ट और सेशन जज शियालदा 1 नंबर कोर्ट आज आरजीकर कांडों का जो अभियुक्त संजय राय उनको जो सजा का म्याद सुनाया वो सजा का म्याद दिया। बीएनएस का जो 64 है 64 में जो रेप के बारे में उनका जो जाबज्जीवन अर्थात जाबज्जीवन उनका सजा दिया, उसके साथ फाइन किया। 66 जो है रेप एवं उसी टाइम में जो टॉर्चर के बारे में उनका डेथ हुआ, इसलिए उनका अमृत्यु जब तक जिंदा रहेगा तब तक उनको जेल रहने होगा। एक ही साथ उनको फाइन भी किया और 103 का एक जो बीएनएस एक्ट है वो उसके बारे में जो मर्डर है उसके बारे में उसके लिए उनका जाबोजीवन कारावास का सजा सुनाया, एक ही साथ में फाइन भी किया, एक ही साथ में स्टेट को गवर्नमेंट को डायरेक्शन दिया। लॉर्ड एडिशनल डिस्ट्रिक्ट सेशन जज 1 नंबर शियाला कोर्ट जो 10 लाख को 10 लाख एंड 7 लाख टोटल 17 लाख उनका फैमिली को देने होगा एज पर क्षतिपूरण विक्टिम फैमिली को लिए। कैपिटल पनिशमेंट हम लोग मांगा था सीबीआई का तरफ से और फैमिली का तरफ से, फिर भी कोर्ट जो बोला ये रेयरेस्ट मैटर नहीं है, इसलिए हम फांसी का सजा नहीं सुना रहे। हम उनके मृत्यु कारावास 66 के बारे में और 64 एंड 103(1) के बीएनएस एक्ट के बारे में उनका जाबोजीवन कारावास का उनका घोषणा दिया कोर्ट। एडवोकेट अनीशुर रहमान, हम एडवोकेट है इधर का, हम एडवोकेट अनीशुर रहमान है।
Well, at this point, I'm joined by Dr. Ranjana Kumari, a woman activist and chairperson of Women Power Connect. I am also joined by Sanjay Sahai, former IPS officer. Let me go over to Ranjana. Ranjana, you know, your first reaction to Sanjay Roy, the alleged murderer and rapist of the medical student, has been given life imprisonment.
I think we welcome the punishment, but two things. One, of course, we welcome that this was really done in a very, very quick process. We didn't have to wait for years to get this judgment. And this is something we really appreciate local court for they have done this. But you know, CBI has failed to prove that this was rarest of the rare. Wherever and her body was brutalized, she was killed, she was murdered, raped and murdered. So this is certainly comes under the category of rarest of rare. But, you know, this is the failure of the investigation agency, which could not really present the investigation report in a manner in which court should have been convinced of the seriousness of this whole crime. However, the swift punishment and a punishment for whole life in jail is something that we really appreciate, that whatever they could prove, at least quickly they have punished. But second thing also, I want the local bureaucracy and also the police to ensure that this man never comes out of jail. Because, you know, what happens after a few years, it'll be out of mind for everyone, and he may get bailed for, you know, for whatever reason that he can present to. And then, you know, there is risk of such people coming out and committing crime. We have seen it has happened in the past. So I only hope that it will be ensured that he doesn't come out of jail for any till last day of his life.
Let me also go over to Mrs. Sanjay Sahai, a former IPS officer. Mrs. Sahai, do you agree that CBI has not been able to build a case to call it a rarest or rare occurrence?
I think the CBI tried it level best to make it as the rarest of rare cases and plugging all the loopholes on account of the scientific investigation and the reports thereof, and going through a large number of evidences and circumstantial evidence also. Might be in the first few days, some of the evidence was lost out. We are not very sure about it. And the second and the most important thing, that however best the evidence is produced in the court, it depends on the judgment of the judge who is there, how he evaluates the evidence which is provided to him. To best of my understanding, to the concerned presiding officer, the judge, so it was not sufficient enough to be called rarest of rare cases. There is a subjectivity which certainly lies with the judge, and that subjectivity is used. We are very happy about the fact that it has happened in a predictable manner, and there's life imprisonment which has been awarded to him. So beyond that, it will be very difficult to comment on the judgment part of it, on the capital punishment.
Part of the investigation, there is a severe laches which we pointed out in our argument, and today is the result of such a investigation, whereby we always prayed for the highest level of punishment, but the learned court has given the life sentence of the accused person, and we have pointed out the laches of the investigation that created a confusion in the mind of the learned court. That is the reflection of the judgment.
By
Later,
of confusion, this judgment has come.
Later the judgment will come, the copy of judgment, and the elaborate part of it will explain as soon as we get the copy. Thank you.
The parents has denied the compensation, but the court has stated it that the compensation is not such a compensation that the court is giving. It is the liability of the state. It is the liability of the state which was supposed to give. The parents are partially happy, and the main point is that the parents wanted to convey before this learned court through us that yes, there are discrepancies in this investigating procedure. So we have pointed that out, and the state has been reflected in the judgment. That is what. হ্যাঁ বলছি অবশ্যই অ্যাপিলের প্রভিশন খোলা আছে এবং the court has specifically stated that liability of state is to give protection to the daughter when she was on duty. So এই কারণে এই যে কম্পেনসেশনটা দেওয়া হয়েছে সেই কম্পেনসেশনের পার্টটা is off for this.
Well, the lawyer is also saying that the judgment is open to appeal. Let me go over to Dr. Aparna Mohanta, who is a general physician. She has been protesting against this gruesome crime. Your first reaction, Dr. Mohanta?
Good afternoon. Thank you for having me on the show. Today the verdict is out, but very sadly, justice is still lagging far, far behind. There's no rejoice and cheer today in the verdict. The compensation of 17 lakh, which the government of West Bengal is liable to pay, does not account for the gruesome murder that had been committed while the girl, the postgraduate trainee, was on duty. Having said that, I would make it brief. The world is watching as much as we, the common man, is watching too, the pillars of democracy. Let them rise up to the common man's aspirations. We are very tired and weary of all the rhetorics, the political, the social, the media, the judicial, all the rhetorics. We want the justice to be delivered in tandem with the verdict and not in bits and pieces. Today is no rejoice and cheer for us.
Dr. Mohanta, you have been very close to what was happening on ground. One of the things that Sanjay Roy, the accused, has constantly said that he is not the only one involved in this, and he kept repeating that he hasn't committed the crime, but there are other people who are involved in it. Being so close to the action, do you also think that there are other people who have got off because of lack of evidence that CBI has failed to build?
Yeah, of course. I'm such a small person in the cog in the wheel. The entire nation believes. Anybody with a little bit of intelligence cannot put their hand on their heart and say, no, this was just Sanjay Roy who happened to be the criminal of the entire proceedings. Never. I don't believe. And being a very, law-abiding citizen, I cannot question, because I have been trained right from my school. My parents, my system, everybody has conditioned me not to question the system. But then we can't only do and die, right? Neither the child deserves to do and die. Let the judiciary rise up. Let it deliver justice and verdict in tandem. Let us all rejoice then. Let it be like that. Yeah. I can't add on more apart from that.
Yeah. Mrs. Sahai, would you like to react to what Dr. Aparna is saying?
What Dr. Aparna is saying holds good in a variety of ways. What is important is the total degradation of administration and art taken, and how that facilitated into this crime happening. I say it is a matter of conjecture for us, but it should not remain a matter of conjecture for investigation. And even on that fateful night, mostly this person was drunk. He joined as a police volunteer. What is the background investigation which has been done? And the nature of administration provided by the medical superintendent, which is all known and it is out there in the public domain. The 5 persons' DNA, which was there on the victim, plus 68 people who have been there in the video footages, I think certainly little more needs to be done so as to prove it to the world that this is, there has to be finality in it. There is nobody denying the fact that whatever has happened so far and the way CBI got into the scene and made a case of it and has successfully handled it for the main accused of the case in a very short period of time and got life imprisonment, if not capital punishment. That is certainly very, very praiseworthy, and it goes to the credit of the CBI. But I'm not denying what they have given in this particular case. Certainly, there are some loose ends. These loose ends we have been talking about from day one of the case. I've been appearing on large number of TV panels in those days for nearly 2 months. And the way state government actually appeared on the scene, and I think their demeanor was also not to the mark of a government which controls the police and which takes the responsibility of investigation. To best of my understanding, and certainly all of us are conditioned not to differ with whatever government says, what the judiciary says, and what the top investigating agency in the country says. But there is also, I think, some amount of background understanding and a narrative by which we are forced to question quite a few things, given the present nature of things, the way they are happening.
Right.
So I think it would be a very pleasant situation if the Supreme Court of India gives a chance for a High Court monitored investigation with regards to all other allegations. We can call it allegations as of now. All other allegations leveled by the parents and more so the mother of the victim. I think certainly, see, the end of the day, why an investigation happens, why a trial happens, it is the closure. Why do we do final rights of people? We do it because there's a closure to life. So the criminal case, it needs a closure. It's not that it is the logical, legal culmination of something. It is logical, legal culmination of a crime which has happened by which the whole society has been perturbed. So that has to be laid to rest. If that is not laid to rest, it does not make any sense whatsoever. So that is broadly, that is my thought, and I've got into a variety of this, from the technical, legal, governance, scientific investigation, literally any and every point of view.
Mr. Sahai, hold your thought. We are going to come back to you. At this moment, let me go over to my colleague Saurabh Gupta, who joins us from outside the Sessions Court in Sealdah. Saurabh, tell us about the sentiments that you're picking up on ground. There was widespread anger. Kolkata rose against such a gruesome crime. Would people on the street be satisfied? I'm not talking about happy. Be satisfied with this verdict today?
Yeah, absolutely not. You know, there was a sentiment that this was a case that deserved the death penalty, at least amongst the general public. We're not getting into the legal formalities and the legal arguments of it. The legal arguments have been made within the courtroom, and the court has decided based on the legal arguments. And the court was very clear in its reasoning as to why it felt this was not in the rarest of rare categories. Those are reasonings that would be perhaps even more clearer once the certified copy of the judgment is out later in the evening. However, we see protests just on the other side from where I am that are taking place, and this will further perhaps generate more protests, given the fact that many believe that this was a case that fell into the rarest of rare category and that was deserving of the death penalty. However, like I said, that is a general sentiment. Legal process and legal arguments are very different. They take place in, ideally in a situation where, it is only the evidence that comes before the court that is considered. And you cannot, of course, expect, judges to be swayed by public opinion. Judges will decide based on the evidence before them. That is exactly what the judge said this afternoon while hearing the arguments on the quantum of sentencing. And therefore, the judge, once he came out at 2:45 to deliver the sentence, he said that this is a case which, in my opinion, does not fall in the rarest of rare category. And I must also add, on the part of the defense lawyers also during the quantum of sentencing argument quoted some very important Supreme Court judgments, quoted some very important precedents in law that would obviously be, towards life imprisonment and not the death penalty. And those arguments also were important. In fact, if I can just try and read out some of those arguments, which perhaps also would have gone in favor of the accused in terms of the life imprisonment. And those arguments are very clear. And those arguments were in the sense of multiple points. One is, of course, whether the doors of reformation have been completely closed or not before someone can be removed completely forever from society. And that is by the death penalty. Because the death penalty is something that is given when a court believes that there is no case of reformation here. And of course, the prosecution said that this was, a rarest of rare category, the brutality of the crime, the fact that the young lady postgraduate trainee was, at a government hospital providing service to the poorest of the poor. And this is when it happened. But the defense said that there has to be evidence as to why reformation is not possible when you award death penalty. The court said, Supreme Court says when you're praying for death penalty, you have to provide the evidence of reformation is not possible. Death sentence is to be given when all doors are closed. There has to be evidence on record on zero scope of reformation. There is the doctrine of residual doubt. This is a legal doctrine that often is made, and a legal doctrine that's used in arguments when there is a quantum of sentencing. And the quality of evidence has to be higher for the death penalty, even if it is enough for conviction. And also if there is lingering uncertainty beyond reasonable doubt and absolute certainty, then death penalty is often commuted. And there is a NLU Delhi report on this, which was also quoted by, the defense lawyers. This is a report this is the first of its kind. It is by the National Law University in Delhi. And then, of course, the defense ended its argument saying, therefore, the court may consider alternate punishment apart from the death penalty. These arguments seem to have stuck in court. These arguments seem to have had an impression on the court while arriving at its decision to award the life sentence. Also, when we were speaking to lawyers in the past, one of the things that they kept saying was that eyewitnesses in terms of, someone seeing the accused commit a crime. It was all electronic evidence, it was forensic evidence, it was evidence that was gathered at the spot. But many believe that perhaps even if it secures a conviction, it's not enough to secure a death penalty, given that doctrine of residual, what I was saying, as the defense lawyers argued, that there was the doctrine of residual doubt. So obviously, these are legal arguments that have been made in court, and these legal arguments seem to have stuck outside the court. There are legal processes inside the court. There is a public opinion outside the court. When it comes to the public opinion and the general public sentiment outside the court, it is very clear that everyone believed this was a fit case for death penalty and not life imprisonment, as the court has decided. But again, the court has to work on the basis of evidence. That is something the court made it very clear. It will act only and only on the basis of evidence presented before the court. And no matter what the public sentiment is, the court seems to have gone by the evidence before it and decided on life imprisonment, along with fines.
Right. Saurav, I'll also have to ask you about that one, information, I would say, that the accused has been constantly saying that he had not done the crime and there are many other people involved. He also mentioned that an IPS officer knows everything and he's not being allowed to talk much. What are we really picking up on those, on those accounts? Are they all fictional, or there is some weightage to what he is saying in the court?
Well, let's first tackle the question that you had in, opportunities in court to argue his case. The accused the court has heard him for 3 hours on one day. That's something the court made it clear. The court has given him ample and every opportunity to make his point in court. And that is something the court has considered while arriving at the verdict and also during the quantum of sentencing. So no accused will ever say, I am guilty, I did it. Accused will always try and evade responsibility for any crime committed by the accused. But in this case, what many also argued was that that perhaps it's important because also even more important because the victim's family seems to be also going by that argument that there could be involvement of others, that there are allegations of a cover-up. However, at this point, again, we must remember that the CBI is the investigating agency. The Kolkata police initially invested the case, and the CBI presented all the evidence, and the evidence was not weak. The evidence was pretty strong in the court. And based on that, the accused has been tried, he has been held guilty by the court, and then he has been sentenced. So obviously, if the evidence was all wrong, then the accused wouldn't have been, convicted. So the evidence is there. However, what is missing, or what the parents say is missing, or what several political parties have alleged, is that there could be involvement of others, but the evidence on public domain after months of investigation do not seem to suggest that. That does not mean that there could be no evidence. It is still an ongoing investigation when it comes to the charge of destruction of evidence. The CBI has made it very clear. So it's an ongoing investigation in certain areas. The evidence that has been presented in court is against Sanjay Roy, whom the police and the CBI maintain in the charge sheet that he is the one who committed the crime. And he has been tried on the basis of that evidence, and he has been convicted, and he has been sentenced to life imprisonment.
Well, Saurabh, we will keep tracking this story very closely with you. We'll of course have to wait and see whether CBI appeals to a higher court or not. This judgment is open to appeal, so lots of different layers of the case will perhaps also unveil before us over the next few hours. We will get to know more and get our viewers all that we know about this story. For now, we know that the accused in Kolkata rape and murder case, Sanjay Roy, has been subjected to life imprisonment, and he'll have to pay up a penalty of 50,000 rupees. He escaped death penalty in this Arjikar rape and murder case.